Chapter 5, initiating the mediation session. The initiation phase, back when I briefly mentioned the stages earlier, the initiation phase is, to me, the most important part of the mediation session, because this is where you establish your authority. This is where you establish and go over the rules. This is where you lay the groundwork for the entire mediation session. Here's where you set the ground rules and the parameters. It begins the process of gathering the information by encouraging the parties to begin telling their sides of the dispute. Prior to starting the mediation, the mediator needs to ensure just some logistical things have been taken care of. For example, that there's pens and paper and note paper. You should always have a calculator handy. Other things that are going to make the process go smooth, that you don't have to stop the process and go hunt and search for something. The room selected for the mediation should be private. There should be no phones, which would be ringing, and pagers and all of that type of thing. The mediator should also have access to a photocopier to make copies of any agreements or any documents necessary to conduct the mediation. Well, that really has always never really been a priority for me as far as making sure there was a copier, because lots of times you're doing mediations where you don't have access to a copier. So if you don't have access to a copier, how do you make a copy? Just write another copy of it. If somebody just has to absolutely have one that night, then you just write another copy of it. Okay? But in some cases where I've had long agreements, I have them sign it, I sign it, I take the original, and I'll tell them I'll mail them a copy later. Okay? But don't ever let them leave without, if they've agreed to it, without signing the document. Okay? Let's talk about setting up the room, though, for just a second. One of the critical things is the seating arrangement. Well, ideally, the seating arrangement, you've got a table such as this, and you've got a mediator sitting here and another mediator sitting here, one party sitting here and the other party sitting over here. Okay? If you have three parties, then you would put another party over here. Now, what some mediators teach, which I think is wrong, is they have a mediator on one end of the table and a mediator at the other end of the table. The problem with this format is that when this mediator's talking, both of these people are looking over here, and this mediator cannot observe their body language and see how they're responding to his questions or her questions. Okay? And the same thing, when this mediator's talking, he can't see the other parties. Okay? So to avoid that, and they've got this thing called line of sight or line of fire. No matter who these people are talking to, both mediators can see both parties at the same time, and can see when one person's speaking and see the body language and how that other person's responding to it. So the mediators need to be together, and the mediators need to be together for other reasons, in case they need to communicate with each other. Now, not openly or whispering to each other, but just subtle ways of communication. We'll talk about that when we start doing some of the role plays. But the mediators need to be on the same end of the table with the parties opposite each other. Okay? Yes?
Can you tell me why you would typically have two? Because in my mind, I would typically think of one mediator going in there. Is that your rule of thumb, is that you try to take another one with you? Can you hire more than one mediator to be in there?
Well, I'm sure you can hire as many mediators as you can afford to pay for to be in there. There's multiple reasons I teach and use the co-mediation model. First of all, in divorce cases where you have a male and a female, you want to have that equal balance of gender there. But you also want that other perspective. And as a professor and as a teacher, it makes it easier for me to train somebody if they're sitting next to me in the actual cockpit, in the actual session, that they're actually a participant in the mediation process. And so for educational and training purposes is one of the primary reasons that I do the co-mediation model. Because You know, you may be in the room. Let's say you're sitting over here in a chair as an observer. You know what? You're not going to learn near as much as if you're in a pressure position as a mediator. You're going to be seeing it from a whole different perspective. When these people are looking at you to be their savior, to come up with the answers that's going to resolve whatever issues that they're having, then the best way to do that's in this co-mediation position.
So for you, most of it is going to be a training situation.
For the most part, it is, or just to let people gain more experience, right? Absolutely. But there's lots of advantages of having this other perspective here, of having this other perspective of another mediator in the room. Okay? Now, I've done lots of mediations by myself, don't get me wrong there, and does having a co-mediator ever get in the way? Well, it's never been a problem for me, but some people might be intimidated by having a co-mediator because they feel like that they're in competition for who's going to be the best mediator. Well, and when I mediate with people that are more experienced than me, which there are not a whole lot of them around, but in my earlier days there were, you know, I would let them play captain mediator, you know, and I would sit and listen, because by listening and observing all the parties and their reactions to it, then that helps me probably formulate the one or two questions that I can ask that might help resolve this thing. Okay?
I remember you saying the magic number is 10. With sitting in the cockpit, we could count that as one. What about if you're observing?
Yes, you could count that because you're involved in participating in a real mediation session. Yes, absolutely. Okay. Yes, ma'am. Where do the attorneys sit? If they're a mediator? If they're representing the parties? They can really sit wherever they want to, but it's pretty interesting watching the dynamics. If you have a party and an attorney, the attorneys typically sit behind them. I can't ever remember a time when the attorney sat between the mediator and the party. Although it may have happened, I just don't recall it. It's almost like husbands and wives. The husbands always sit behind their wives. Don't know why. Maybe some psychologist could tell me why, but it just seems to work out that way. And safety. So the wife is the buffer between the mediator and or the husband's watching her back. Is that what it is?
You know, you're talking about the decision maker, and we're talking about husband and wives. We've had mediations where the wife was actually the plaintiff, but the husband was just there. But anytime you'd ask the wife a question, she'd look at the husband before she'd answer, even though he wasn't even there. And we see that quite often.
Yeah, there's no real reason. I don't set them. I seat them on a side, and they can sit however they want to on a side. You know, when they come in, and typically, I'm kind of stubborn this way. I'm a left-handed mediator, which means if you're co-mediating with me, I'm always going to be right here on the left-hand side of the table. I don't know why I can't. It's hard for me to think from that right-hand chair. I don't know why. It's just kind of the way it is. And when I meet and greet the people and shake their hands, I'll go ahead and direct them, go ahead and have a seat over here. And they can sit on that side however they want to. Now, when these people come in, and if you've got your seating arrangement, one of the other things that you want to arrange is on your notepad that we talked about earlier. And on your notepad, so we've got this table set up, and I draw a little miniature diagram at the top of my notepad, okay? And I'll put my name, so it'll be Gary and Patty, just as a reference point. And then when we start going through the opening statement and we get them to agree to first names, I ask them what their name is. And I go ahead and write their name. Let's say it's Ron and Tom and Sue and Bill. You know, I'll ask them what their name is. And go ahead and take the time to write it on the sheet of paper first of all, that lets them know that their name is important, and it's important to me that I get it right. And for the whole rest of the mediation, I'll know what these folks' names are. Remember, I've just met them. I may never, you can't always go by the style of the case, and the style of the case may be William Roberts. Well, he may not go by William. He may go by Bill or Bob or something else, okay? That's just kind of a little note-taking deal there that's part of the beginning of the process. Well, we're talking about now the mediator's opening statement. And the example that you have in your books, in your guidelines, that's an example of an opening statement that one of these DRCs uses. And I'm going to kind of use this as a kind of a how not to do your own. And if you want to go through it and compare it to the opening statement that I provided for you in the handout, the one that I actually use. Well, this mediator's opening statement, this says, hello, I'm, mediator, state your name. Hello, I'm Gary Lacefield, and I have been asked to be the mediator in order to help you work out a resolution to the disputes you've been having with each other. My role is that of a facilitator. I will not make any decision with respect to resolving this dispute. This meeting is not a legal or judicial hearing. It is an informal meeting to try and resolve this dispute to the satisfaction of those who are involved. Before any formal process such as a trial becomes necessary, this meeting is confidential, and no information learned here may be taken out of this meeting and used against any other participant in the mediation. It is my intent as a mediator not to reveal any information discussed here today with anyone not involved in this case. I ask that each of you also agree to respect the confidential nature of this session and further agree not to reveal any information revealed by either side during this mediation. Whew. Okay. Well, and that's how the participants feel. I mean, that's a lot in that first paragraph, okay? And as you can see in mine, I've kind of shortened that up a little bit, and I've got it set up to be in the co-mediation model. Say, hello, I'm Gary, and this is Bill, and we're mediators who have been asked to help you work out a solution to the disagreements you've been having. This meeting is not a legal or judicial hearing, but it's an informal meeting in which we attempt to resolve disputes between parties. And as the mediators, it is not our intent to share any information we discuss here today with any others not involved with this case. Now, some of the things that I've cut out are things that you don't want to use them up front. You want to use it as a tool later on. Things such as in the middle of this opening statement where it says, before any formal process such as a trial becomes necessary. Well, we want to use that as a tool later on in the process. We want to say, you know, if we don't get this resolved today, then what's going to happen? Well, it's going to go to trial, okay? So use it as a tool later on. Don't confuse and muddle the issue, and don't start talking about negative stuff in the opening statement, okay? Because here we're reinforcing the fact that, you know, if this isn't resolved, it's going to go to trial. So, you know, we're just wasting our time here in this mediation session. Why subconsciously remind them about that if you don't have to, okay? The second paragraph in the book is, it is my understanding this case was brought to mediation by Bill. Is that correct? Well, first of all, why alienate one or both sides by reminding them that Bill filed against Sue? I mean, that's already on the record. That's already knowledge. Why go ahead and reinforce that in the mediation? It's just it's a useless, negative. Both parties are there. They're here to mediate. What difference does it make who brought it to mediation? It doesn't. It's irrelevant. It's just another negative statement that could cause you to delay the resolution process. I go next to, do each of you here, mine is, we know that you're here voluntarily in an attempt to resolve this dispute between you. Okay. Well, some people at this point might say, well, I'm not here voluntarily because the judge ordered us to be here. And I said, yes, the judge did order this to mediation, but you had a choice. You didn't have to be here, but you did. You are here. And so, since I don't see any of y'all chained to the table, I'm going to assume that you're here voluntarily. Okay? back to the textbook's style, it says, do each of you here today have the necessary authority to negotiate the issues, commit to, and sign any agreement which may be reached in this meeting today? You know, that's a pretty good little statement, and so mine's very similar, almost word for word. And again, you need to wait for acknowledgement. You need to look at each party and make sure that they give you some type of acknowledgement that they've at least heard what you've said, okay? The next sentence, does anyone have any reason to believe that I cannot be fair and impartial? Well, this is the part where I have worked in a smooth transition into the co-mediation process. Where after I've talked about, do each of you have the authority to negotiate the issues of the case and sign and commit to any written settlement agreement? Then I move into, at this time we have some procedural ground rules, and this lets my co-mediator take over from this point, even if it's a student, because this allows them, this shows the parties there that we have a real mediator there, and that they're not just an observer, that they can participate in the process if they so desire. Matter of fact, the participants won't know that this person sitting next to me is a student. Okay? People hardly ever ask me. Matter of fact, lots of times people ask me how many mediations I've done, and I'll say, you mean counting today's? And they'll say, yeah, and I'll say, well, let's see. 4 counting today's, 5, 6, irrelevant. But, they telling them 800 or 900 doesn't impress them as much as whatever you might think, but anyway. And when I'm doing this opening statement, I tell my co-mediator, as well as I will be exhibiting that, and I tell the parties, I'm going to be reading this statement so that I don't miss anything, okay? And I actually have I use a little ruler that, because you're looking up and getting acknowledgement in each section and each part of this process, and I'll use my little ruler and slide it down so that I don't lose my place, like I've done here a couple of times, when I'm giving the opening statement. Okay. So we're going over some ground rules, and the first ground rule in the textbook is each party and each member of the party will be given a chance to speak. Therefore, can we agree to refrain from interrupting each other in order to facilitate the flow of information and expedite the mediation? Well, over here, I've made this a little more formal and a little more specific. I say, since this is an informal meeting, can we agree to use first names? And stop right there, okay? I say, my name is Gary, and this is Patty, and you're Byron, and you're Lisa, and you're Victor. And as they're giving me their names, I am consciously writing their name down so that they can see on my sheet, okay? And once you've done that little exercise at the beginning, you don't have to worry about it anymore. One of the worst things you can do in a mediation process is call somebody by the wrong name, okay? So, I mean, there's lots of worse things you can do, I guess, but one of the bad things you can do is to call somebody, miscall them a name, okay? Then it says, do either of you know me or my co-mediator have any reason to feel that we cannot be fair and impartial? And then I stop and I wait for acknowledgement. Now, lots of times you're going to do mediations. If you're in the mediator world, then you're going to see attorneys over and over again, and then you would still mention that. I think I've done mediations where you represented other folks before. I mean, if you recognize that person, go ahead and make that statement known. Because you need to make it known now, because if you don't, if later on in the mediation, one of the attorneys that you've sat in on 2 or 3 mediations with before, and the attorney says some statement like something off the wall like, well, you know, the last time we had a mediation, you didn't ask that question. Well, the other side says, whoa, 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 wait a second. Y'all been in mediations together before? Well, why are we just not hearing about this? Well, this is the time to disclose that, okay? Now, that doesn't mean that you can't do this mediation, because you know, you weren't representing a side, you were the mediator, they were an attorney representing a client, okay? So if you know that, go ahead and disclose it. Now, obviously, if you know one of the parties, if you're doing one of these in one of these volunteer areas, arenas, you know, you don't know the parties who you're going to be mediating with until you show up. You show up and you're given a little slip of paper that says it's Smith versus Jones and this is an employment case. Or this is Smith versus Jones and it's a divorce case. Or this is Smith versus Jones and it's whatever it is. And so, you know, you may have some knowledge of or some relationship with one of those parties. Now, in all the mediations I've ever done, it's only happened one time. And this was back when I was with HUD. And since I was a regulator and enforcer of fair housing issues, it turns out that the case involved the multifamily property, and this happened to be a multifamily property that, about 6 or 7 months earlier, I had given them the opportunity to pay about a $30,000 civil penalty. Okay, and so when I recognized the name of the management company, I called parties together and I said, well, you know, in my role with HUD, I had I had an opportunity to work on a housing issue with them, and the company that the people representing the management company said, yes, we recognize your name and we felt that you were fair and impartial with that, so we don't have any problem with you being our mediator. And the other side, figuring that the only time a management company is going to have a problem with HUD is if they got in trouble, they were very happy to let me continue. Okay, but that's the only time. But if you ever think that there's an issue, you need to disclose it at this time. Okay, because you don't want to go through a whole mediation process and then ultimately turn out that there's some ethical reason that you should have recused yourself from this mediation. Okay. Each party and each individual member be given a chance to speak, and therefore can we agree to refrain from interrupting each other in order to facilitate the flow of information and expedite the meeting. Okay. Very similar to what they have, what we have over in the textbook. Back to the textbook, there's a sheet of colored paper on the table in front of you. If you need to take notes to be able to respond during your turn to speak to something someone else said, please use this form. Okay. I've kind of changed that up and made it a little more user-friendly on mine. It says, notes may be taken to assist you in making your statements or in asking questions when it's your turn to speak. Any notes made, however, must be made on the color forms provided. They will be collected and destroyed at the conclusion of the mediation. Now, if you'll notice back in the text, the statement that the DRC uses, it says, if we agree to recess and return at a later date, the note forms will be retained in my confidential file of this case until the mediation is finally completed and will then be destroyed. Well, you know, if we get to that point, I'll tell them about that rule, but I don't want to subconsciously implant in their mind that it's okay if we don't get this resolved today because we can come back and do this another time. Okay? So there's no reason to subconsciously plant in their mind that we're not going to get this resolved today. So I don't read that. I use mine. The next one, it says if it becomes necessary for any of us to meet privately, can we agree in advance to that possibility? Okay. Once again, I've changed that up a little bit to say it may become necessary for any of us to meet privately or take a short break. We refer to that as a caucus. Can you agree that would be okay if necessary? Okay. Once again, after each one of these paragraphs, you're looking around the room and getting an acknowledgement from all the parties involved. Are there any questions before we start? Now, that I go straight from the caucus to, are there any questions before we start? Over here, they've got what I think is a completely unnecessary statement that says, it may become necessary for me to excuse the third parties present in order to facilitate the progress of the session. If, in my opinion, that becomes necessary, I will so require it. Well, I don't allow any third parties. You're either a part of the decision-making process and are in the room, or you're not. There are no third parties allowed in my mediations, other than people who come in to give specific technical or technical statements or expert opinions. Okay? Are there any questions before we start? Now, we've already gone over all these rules. The people are not listening to you to start with. They're worried about what they're going to say in their opening statement. Okay? So I just go straight into, everyone will have the opportunity to make an opening statement. Please remember not to interrupt each other. We will begin discussions of the issues after each of you have completed your opening marks. And then I turn to who I think is the weaker party and tell them to go ahead and make their opening statement. Okay? Well, what if this person's on the left-hand side? And the person on the right hand, like Byron, jumps up and he says, well, why'd you let her go first? Well, then I'd say, well, I always go clockwise. Okay? Well, first of all, nobody has ever challenged me on this, but I always thought that if I was ever challenged on who I picked first, well, clearly I'm not going to say, well, I think she's the weaker party, so I'm letting her go first. That would be bad form. And so I just always you want to be prepared for a potential challenge. Okay? And so what if she says, well, why'd you let Byron go first? What would my answer be? I always go counterclockwise. And then I'd say, Byron, go ahead. Because still my decision. And so I'm going to stay focused on the person that I chose to go first. Okay? I don't say, well, Byron, is it okay if she goes first? Because now it'll be a debate. Now you've allowed additional conflict to start. Because Byron's going to say, well, no, you asked me to go first. I want to go first. Or Byron says, well, you know, I don't know. She always gets her way, or whatever. You know, you've just opened a can of worms. You need to maintain control. Okay, so that's how you would handle it. That's, I guess, how I would handle it if I ever ran into that. But never happened to me yet. But never say never. Now that's how I do a smooth transition into the opening statements and allowing the parties to give their opening statement. Over here, they've got some things in there. For example, it says, one last thought before we start. Please understand that this may be your last and only opportunity to resolve the dispute between the two of you. More negative talk. If you fail to settle here today, you may be required to await the judgment of some authority who knows neither of you and is governed by a legal code which is cold and unfeeling in its attempt at fairness. More negativity. You may be required, therefore, to accept a judgment in which neither of you will be in agreement. More negative stuff. So before we start, I want to remind you of these things to possibly motivate you to work all the harder to come up with an acceptable resolution to the dispute the two of you are having. Okay, how much of that do you think they heard? For sure, if they heard any of it, it's all negative stuff. Okay, so once again, this is the kind of opening statements that you're going to have at some of these DRCs or at some of these volunteer centers, because somebody has convinced them that you can save a lot of time by go ahead and talking about all the negative stuff that's going to happen if we don't get this resolved. Well, for the most part, truly, people really do want to get the problem resolved, although they may not freely admit that, but they do want to get the situation resolved. Now, they have theirs at the bottom. It says, whoever the initiating party is, since you brought this dispute to our attention, you may make your opening statement first. And then you turn to the other side and say, you can make your opening statement. Well, once again, my philosophy is you let the weaker party make their opening statement first. That way they're not defending their position by following who may have been the stronger party. So once again, mine is just a little bit, I've cut through the chase. I've identified who's going to go first. Yes, sir.
Well, I was going to wait till you finish your sentence. How do you handle it when, say, the lawyer launches off and starts with an opening statement? How much participation do you let their lawyers have?
If they're in the room, they're a member of the party, and every party has the opportunity to give an opening statement. If you've got mom and dad and Uncle Ned and two attorneys, every one of them have an opportunity to give an opening statement. Odds are, though, if they're represented, many times if they're represented, the parties say, I'm going to defer to my lawyer, or the lawyer's got the statement for me, and the lawyer makes the statement in many cases. Okay, but I've given the parties the opportunity to give the opening statement. Now, for example, let's say that I've determined that Ron is the weaker party here. Let's say Ron, Tom's a representative over here, Sue's a representative for Bill, and I know that Tom's the attorney. I literally am going to go counterclockwise. I'm not going to jump from Tom to Sue to Ron to Bill. Okay, and it's very important that you do this. Now, it seems like a little minutia here, but here's why. Not all the time are you going to have cases where you just have two parties involved, represented by two people each. to me, that's actually going to be a rarity, okay? I did one case one time where it was an old workers' compens case. There were 16 parties in the room, represented by 30, there were 35, 36 people in the room. Most of the people representing the parties were attorneys and insurance agents, or attorneys and risk managers, or risk managers and HR people. But there were, and it was a pretty interesting case. Matter of fact, it was one of the oldest workman's comp cases still on the books. And my co-mediator was a lawyer, and pretty interesting guy. But anyway, because we had a room full of attorneys, that, you know, they didn't go over the rules. They were just talking about potential liability and who's going to, you know, what percentage, if anybody had responsibility for this and that and this and that. And so, but anyway, what I did was I did my table, went around the room and marked everybody down so I knew who was sitting where and who represented. Like, for example, if Ron was the insurance agent, I did my own little code here and put an I after his name. If Tom was the attorney, I put an A after his name. And the A stands for attorney, not something else. So that way I knew what role they were playing in this mediation session, and especially if you've got, I've done lots of mediations where there were 12, 15, 18 people in the room. And so if you don't practice doing it with a few people, it's going to be very difficult to pick that up when you actually really do need it. Also, the reason that you do it this way is because these mediations can get very intense, even if you're just talking about what seems to be something very, very silly. And you lose focus. As a matter of fact, you may forget what your name is. That's why I write my name down here, so that, okay, this is me, these are the other people in the room. Because you're so focused on trying to come up with, listening to them, first of all, and then trying to identify questions that are going to be relevant, that's going to help resolve this problem, that, you know, you literally may be in a fog. You may draw a blank as to what your own name is, because you do get that involved in the case. Okay? Well, anyway, this case, this workman's comp case, was, the story behind this was, you've got a lady who was in her early 70s, still a full-time employee of a local defense contractor, Generous Dynamics. And what happened was, she stepped off of a ramp. She stepped off of a 1-inch high ramp. Well, it was a long ramp, but it lacked 1 inch touching the ground. Okay, and she stepped off of it, wrenched her back, had to have $68,000 in back surgery. Okay, and so her and her lawyer sued. They sued the people who manufactured the ramp. They sued the people who installed the ramp to the building. They sued the people who owned the building. They sued the property management company that managed the building. They sued the owners of the building. They sued the people who were delivering the product. They sued the people that owned the product that was being delivered. Anyway, there were 16 different parties that were sued, and they were all there at this mediation hearing session. And I was a medic in the service, and so medical files kind of always intrigued me. And since the lawyer was playing lawyer, and I had this medical file in front of me, which there were 2 volumes of it, and I think it was like for the last 10 years and from the 10 years previous to that, because this didn't cover her whole medical history. But anyway, I'm sitting there flipping through this medical file, and all these lawyers are arguing about who's going to be responsible for what percentage, even if we, you know, because she was only asking for $2 million plus lost wages and all this stuff. And by this time, she was 72 when the accident happened, and this is almost 6 years. She's 78 years old. Okay, and there was just, I was flipping through the pages, and I saw a copy of a Post-it note on one of the pages, and there was a date on that Post-it note, and the date was about 2 weeks before the date of the accident had happened at the plant. And I'm looking at that note, and it's a note by the doctor, and it recommended, first of all, she had gone in for an appointment, and the doctor had recommended the very exact same surgery that she ended up having from stepping off the that 1-inch high deal. That was a pretty interesting physician who could foresee that she was going to need that surgery. And so anyway, I told my co-mediator that, this would be a good time for a break. He said, we've only been here about 40 minutes. I said, it's a good time for a break. He said, okay. So I showed him what I had found in there, and I said, but let's go into caucus. Let's caucus with the attorney and her client. Now remember, this case had been filed, but nobody had taken a good hard look at those medical records, and if they had certainly overseen this. And so we take this file and we go back there and we say, I'm a little bit confused about this. It looks like you saw your doctor, and here's a note, a copy of a note that's attached to this that shows that he recommended you have the same back surgery 2 weeks before this accident happened at the plant. And her lawyer looked at her and she said, oh, that doesn't mean anything. That doctor didn't know what he was talking about. I said, but isn't this the doctor that did your surgery? And she said, well, but that didn't mean anything. And so anyway, her lawyer said, could y'all excuse us for a minute? So we left her and her client in there alone. And then after about 30 minutes, he comes back in and he says, if we could go back in there and just ask for the $15,000 for the attorney's fees and that our medical costs be covered, we can walk away from this today. Why do you think the lawyer did that?
Because he's going to lose the case.
I mean, if just through casually me flipping through it, I noticed that when somebody actually bared down and examined that medical file, don't you think that they're going to find that? Okay? So we go back into the room, and then we still spend another hour with them, even though we'd gone down from $2 million plus down to, well, the medical costs had already been covered because she was covered under insurance. So basically we were just talking about the $20,000 for attorney's fees. And they still argued back and forth about who was going to pay what apportionment of that. And I just was sitting in there just mentally thinking about the cost that was already in that room. And I bet they had spent that much just in fees for everybody that was in there that day. And so once again, I had to interject because my mediator, my co-mediator over here, captain mediator, was hung up in playing lawyer. And I said, you're talking about $20,000. I said, who in here wants to go back to their company or to their bosses and say, we had this $2 million lawsuit that we could have settled for some portion of $20,000 and we didn't get it resolved. Who in here wants to do that? And nobody raised their hands. And I said, okay, then how can we get this $20,000 covered? And then it brought them back to reasonableness. And it turned out that they all chipped in a couple thousand apiece and we moved on down the road. So, but sometimes you just got to kind of take charge and ask the obvious question. Okay? Okay. Let's go back to, we're talking about the mediator's opening statement and the value of focusing and the value that you're going to get from emphasizing this opening statement. When you talk about hello, I'm the mediator, and I've been asked to be your the mediators for this session, first of all, you're letting them know that it is going to be informal, that you've let them know what your name is, you've given them a level of comfort there. You're talking about what my role you're talking about what my role is, that of a facilitator, and what you're going to be doing to resolve this. Well, let's go back over to my sheet over here, and let me tell you why we do things from my side over here. Okay? We've let them know that they're here voluntarily. We find out in this third paragraph that everybody there has the authority to reach an agreement. That lets us know at that time, if somebody's there and they say, well, I'm here to just represent the company, but I can't agree to anything. Okay, then why are you here? To represent the company. To represent the company on what? This is a mediation. We're here to try to get this resolved today. And so you're telling me that the company didn't send somebody that could represent them and try to resolve this if we reach a reasonable resolution today? Well, I guess if it's reasonable, Okay, so what I'm saying is that, what I'm hearing you say is that you can then represent the interests of the company and reach a resolution if we do reach one today, sign a resolution. And they say, well, yeah, okay. But you want to clarify that because you don't want to go through a whole session and then find out that one of the parties is going to have to take the information back to their boss or to their company and then try to get a signature. That's not going to work, okay? And I've been very, very fortunate in that by stressing these rules and being clear and specific about them, that has never happened to me. That when we get to the end, nobody has ever ultimately said, well, you know, I really can't sign that because I don't have the authority to do that. When we talk about, at this time, we need to establish some procedural or ground rules, and we ask if anybody knows us. Well, we've covered the issue about whether or not there's going to be any ethical issues about anything that we might know. Then we say, can we use first names? Well, first of all, that's letting them be personal with us. That's letting us call them by their first name, and it's been said 1,000 times, there's nothing sweeter to a person than the sound of their own name. Okay? Well, also, when we get to a point that there might be an impasse, and they say, well, you know, we can never agree on anything. Well, then you can go back to this beginning, and you could say, well, you know, you agreed to meet here and mediate. You agreed to use first names. You agreed not to interrupt each other. So what else can we agree upon? Okay? Because I'll shut them down. I'll remind them right then that, you know, that's really not right. We can't agree on some things. You've agreed on mediation. You've agreed on using first names. So there's some very valid reasons why you want to emphasize and be very specific about the rules and the opening statement. Okay. Any questions about the opening statement? Okay. Now, when people, because people will ask you if they have a question, what their question typically is going to be is, well, what am I supposed to say in my opening statement? Well, I just simply say, tell us your story. Tell us your story. Tell us what happened. Tell us why you think we're here. Now, I just said 3 questions, and I never tell them 3 questions, which is one of the key things that, one of the key issues that mediators have is that they tend to ask machine-like questions, machine gun-like questions. They'll ask 2 or 3 questions in a row without even thinking about it, because they're going to mention a question, and then mid question, they're going to think of something better to say, or they're going to think of a better way to ask what they were just starting to ask. And so instead of waiting for a response to the original question, they go ahead and ask a second and a third question. Well, that confuses people. So how do they know which question to respond to? So ask a question, wait, slow down. I know you've already got a better question to ask. Let them answer that question, because their answer or their response to your first question, your next question may be unnecessary. And so it may lead you to ask a better question, okay? So only ask 1 question at a time. Okay, we're on section 5.10, where we're talking about mediation notes. Section 5.10, mediation notes. Okay. Well, let's talk about note-taking for just a second. There's an art to note-taking, and the art to note-taking is take as little notes as possible. Okay, that's the #1 key to note-taking. So we've got our sheets up here, and we've got our little diagram at the top, and we've got our names on here. Okay, and so we've got it divided, and which this really makes it kind of neat for note-taking, because anything that Bill or Sue says, you'll, instead of writing Bill's name over here, just write Bill B dash or S dash, and that'll remind you about either who made the statement or who you want to ask the question of later. Now, remember, you're not going to convert this into a dissertation or to a thesis, so you don't need to take all of these full and complete notes. As a matter of fact, the only notes you ought to be taking are notes about questions you want to ask in the future. Notes about questions you want to ask in the future. Okay? Like, Bill said something, and so I want to ask Bill, you know, what about Jim? Okay? Because he would have left something unknown or questionable, and I want to come back and ask him that. So you only want to write 3, 4, 5-word sentences for your notes. They should just be notes to let you know about asking a question in the future. Now, other notes that you might take would be if you're at a point with an issue that you're going to resolve that issue, whatever that point is, and they're saying that with that particular issue, what we want to do is they're agreeing to whatever the terms are. Then what I do is at the bottom of the page, I write, you know, issue 1, and then whatever it is they've agreed to. And I kind of let them see that I'm doing that, because to me, I've resolved that issue. That issue is resolved, done in the bank, although it really isn't, because we haven't committed it to formal paper and signed it. But I want that issue off the table, so I don't put it up here with the rest of the regular notes. I put it down here at the bottom. Okay? As I mentioned earlier, don't doodle on your note pages. Don't draw funny faces or hangman's nooses or whatever it might be. That'll get you in trouble. As it talks about here, you know, the notes are not going to be a complete transcript of the session, because remember, you're going to tear these up. These notes are going to be torn up, yours along with everybody else's at the end of the session. Okay? If you get it resolved, then you know you're going to be transferring some of this information onto an agreement page, and if it's not, then it's irrelevant anyway. You're just going to tear it up. The mediator should be careful not to take too many notes. That will keep them from observing the actions and the reactions of the parties. Well, if your head's down and you're writing notes, you can't see their response to the questions or how they're responding to each other. And remember, as I said earlier, the most important thing is not so much what they're saying, but how they're responding to it and how they're saying it. The mediation notes will help you identify the real issues of the dispute. They help identify the parties' movement towards settlement. Use it as a tool to keep track of the changing offers and demands. And use it as a record to provide the disputants with positive feedback concerning other settlement efforts. Okay? Now, I also use the back of my notepad quite a bit and keep track of things on the back side, especially when you have multiple issues, for example, and as much as possible, you want to quantify these issues. You want to quantify the value of what you're putting on the assigning to whatever the issue is, if you can, if it is a quantifiable issue. And people wait too late to do that in the process, because then when it gets time to negotiate and to give a little here and take a little there to kind of balance the scales, now they end up placing more value on things than they're really worth. So anytime you can establish a quantifiable value for something, you need to do it at that time. Okay? Okay. Any questions about note-taking? Note-taking, it seems like it would be the easiest thing, but my co-mediators, typically they spend most of their time with their heads down writing all these capacious notes out. Okay?